Hello, welcome to another episode of the Akiana Law Podcast, wherein we talk about everything that intersects and relates to the areas of family law and divorce. I am Lonnie Akiona, and today my guest is Kanoa Ostrem. And Kanoa is an estate planning attorney, and that means he creates wills and trusts. Welcome to the show, Kanoa.
Thank you very much. Glad to be here.
And Kanoa is based in Seattle, Washington. And Kanoa, why don't you tell us, how did you get into the world of estate planning? And did I say it correctly where estate planning means you create will and trust documents?
Yes, that's correct. Yeah, so the one class that I really liked in law school was wills and trusts. And so that was the class that I thought, okay, this is something that I could do. So I kind of talked to my professor a lot and figured out how to get into this practice area and what it meant. And that led to me applying to the University of Washington Law School to get an LLM in tax, which is a tax degree that you get after law school.
Wow, so you went to law school, right? Which is like 3 years. And then after that, you got another degree after law school?
I did, yeah, it was painful. Plus your textbooks are the Internal Revenue Code and the regulations.
Oh my gosh.
That's it. It's pretty dry, but it's a good background for what I do. Although most people don't really have estate tax issues, it's good to have that background as well.
And so your LLM again was in tax.
In tax, yeah.
Okay. And so that's your degree you got after law school. And you're originally from where?
From Hawaii.
From Hawaii.
Yeah.
And then so you're up here in Washington, you get your LLM, and you're on your own right now, right?
Yeah, but I got hired from that LLM program directly into like one of the busiest boutique estate planning firms in downtown Seattle with like 10 attorneys doing just estate planning for lots of high-end, high net worth families and middle-class families as well. Worked there for a few years, then moved over to the biggest law firm in town, ultra high net worth clients. But just wanted to work more with middle class families that I felt were being underserved because of the fees at a big firm. So I opened my own firm about 16 years ago. And I've got 3 employees, including 1 attorney and a paralegal. And we do just estate planning, so we see a lot of people, do lots of plans, wills, trusts, powers of attorney, healthcare directives, all that stuff.
Okay. So wills, trusts, healthcare directives, and power of attorneys. Okay. Yep. Got it. So in terms of why isn't it, I guess let's just start with the basic. Why is it important to have a will document drafted?
Yeah, so every adult in Washington should really have a medical power of attorney. That's the person who makes your medical decisions if you're unable to, if you're in an accident and somebody needs to be able to authorize a surgery. Under HIPAA, that can be very difficult if there's no written authorization. So you want to have a written document, and a medical power of attorney is the easiest way to do that. You just get that done, name your trusted person, whether it's a spouse, friend, family member, to make medical decisions. And then you want to have a financial power of attorney as well. That's the person who would pay your bills if you're alive but incapacitated, just in case. And then, yeah, everybody should have a will. If you're an adult, you should have a will. And it's important to have a will, first of all, to make sure the right person is in charge if something happens to you, right? You don't want it to be left in limbo where somebody has to go to a judge to have somebody nominated to become your executor, right? You want it to be just very easy. You want to have a good will, the right person's name to be in charge. They can be appointed without anybody ever having to go to court. And then they can carry out your wishes that are laid out in your will.
When you have to go to court and the court appoints someone, what's that process called?
It's just an intestate probate, which just requires more work. If all the family can come to an agreement and it's a simple fact pattern, sometimes you don't have to actually go in front of a commissioner for that. But if there is any, uncertainty, then sometimes it just becomes a lot harder to get through the process. And it's just so much easier when you have things in writing, and it just doesn't take that long to get documents done.
So my layperson view is this: if you have a will, then there's a clear definition of who gets what and who's in charge of the estate. But if you don't have a will, then that means you have to go to probate court. You don't know what's going to happen. And doesn't that ultimately cost the family more money?
It costs more money, and then it's sometimes the money goes to the wrong person, right? It might go to your
Right.
parents, and your parents are on Medicaid. And so that was a mistake. You wanted it to go to your partner, but you're not married. So your partner doesn't automatically inherit. Instead, it's going to go to your parents by default. And you just disqualified them from getting Medicaid. And, the money is going to the wrong person. And if you have kids, obviously that's the most, that's why people oftentimes are motivated to have wills. You don't want your kids to inherit everything when they're young, right? You want it to be held in a trust. So you can have a will very simply say, there's going to be a trust set up for my kids upon my passing. And this is the trust. And trust is for healthcare and education, but not for retirement at age 18.
Okay. So then would you have the person in charge of your estate when you pass is called the executor, right?
We actually use personal representative in Washington.
Okay. So would you recommend people to use the same personal representative for your will to be the same person in charge of the trust for your kids?
It's usually the same person serving both as personal representative, trustee, and then also your financial power of attorney. Those are all very similar jobs. Generally, who would you trust to manage money? They don't have to be like CPAs or financial advisors. They don't have to be really sophisticated. They have to be trustworthy and smart enough to get some help. But the main thing is that you want somebody that you trust that's going to do the right thing for you and your heirs.
Okay. And in terms of why, now I know, with Google and just a lot of do-it-yourself type of things, I know there's a lot of do-it-yourself type of wills. What's missing on a do-it-yourself type of wills versus using a will attorney?
A do-it-yourself will works great if you're single and you don't have kids.
Okay.
That's just fine, because then you're not setting up a trust for your children with nuances. Okay. You're not having to worry about tax planning, setting up a trust for your spouse. So single people, you can by all means use a program. Okay. It still requires some time to go through that process. May or may not be free. You need to get witnesses and a notary. So, hiring an attorney makes it a lot easier, even for a single person, because they'll walk you through the process. They'll save you a lot of time and then be your witnesses and your notary so that it's done properly.
Oh, I get it. Because for a will document to be effective in the state of Washington, it needs to be signed by two witnesses, and the whose signature needs to be notarized?
The witness's signature. So that's, you really need two witnesses and a notary, or two notaries serving as witnesses that will notarize each other's signatures. So it's a little bit of a hassle right now to get it signed. And then if you have children, you probably want to have an attorney draft the trust. The boilerplate documents you find online oftentimes leave your kids their inheritance when they reach 18 or 21.
Okay.
Those companies are not comfortable drafting longer lasting trusts, whereas we find our clients, when they hear about it, they say, oh yeah, I like the idea of a trust that lasts beyond age 21. I like the idea of a trust that says, if my kids are young up until 18, cover whatever they need, be generous. But between 18 and 30, for example, let's be kind of strict. We want to cover healthcare and education and help with a down payment on a house, maybe a certain amount for travel, a certain amount towards a wedding. And just being, having that trust last longer, making sure you're not going to ruin your kids with too much too soon. Because people don't realize, like, if you factor in your life insurance, your kids would have a lot more money than you do. Even if you feel like you don't have much money, you might have $300,000 equity in your house and $300,000 in your IRA and a $500,000 term life insurance policy. Now that's $1 million to an 18-year-old, and you want to make sure that's really locked down.
Yeah, that's just blowing my mind right now, and it blows my mind because you did my will and trust for me, my husband, and our boys, and even right now, honestly, it's a blank. Like, I don't remember how long it goes for, but even with you talking about, like, we have life insurance, and it's like, yeah, that's right. That's why we got it done, because we don't want our kids to just be in this huge sum of money and they just blow it on stupid things, as we know 18-year-olds may tend to do.
Yeah, that's for sure. And even great kids, who are not spendthrifts, do everything right.
Yeah.
The mistake they often make is they go and have somebody invest for them.
Mm.
They say, "Oh, will you guarantee my real estate project
Mm.
and help fund this real estate project? I'm going to flip this house." Or, "Hey, I've got this great crypto idea." And not to say all crypto's bad, but maybe they get talked into a really bad crypto investment, and so all the investment goes the wrong way. So just even bad investment decisions, even from a good person who's not a
Okay.
big, that tends to be just as big of a problem as like someone buying a Ferrari and having drug parties.
That's a great analogy. I get what you're saying. So in terms of when you're divorcing, let me ask you this. If a spouse is divorcing, would you tell that person, yeah, why don't you go ahead and get a will done now? Like, or do you even have people come to you in that type of situation?
Yeah, absolutely. If you are planning on getting divorced, it's important to update your documents as soon as you can, because until the divorce, your spouse is likely still your beneficiary, likely still
Right.
your trustee, personal representative, and so everything might be going to the person you like the least in the world. So unfortunately, you may have to come up with a quick will as you're going through the process. Once you're divorced, automatically
Yeah.
your spouse becomes disinherited and is no
Yeah.
longer a fiduciary. So that avoids things, but there's that time period, right? Divorces are not
Right.
immediate. And so in the
Nope.
interim, sometimes you've got to get a quick will together, you know, to cover that time period.
Right, because even if you don't, I mean, the way the community property laws work in Washington State, if you don't have a will and you're going through a divorce, if you happen to pass, your spouse is going to get everything because, as you said, the divorce isn't finalized yet. They're not automatically disinherited. Without a will stating otherwise, your spouse gets it. And now that I think about, that's actually happened twice in two situations where clients passed and their surviving spouse got everything because there wasn't alternatives, but um, in the big scheme of things, they had a child together, so it's goes to the surviving spouse. It goes subsequently to the child, support for the child. So uh, yeah, that's a good point, and I always tell people too, once the divorce is finalized, if once the divorce is finalized, if they do have a will, it's always good planning just to update it anyway. Even
Yeah.
though the spouse is automatically disinherited, you still don't want a will giving things to your spouse.
Yeah. And I've had the opposite happen a few times too. I've had it happen where someone died during the divorce and the money goes to the wrong place, or where they would rather have had it go to a trust to make sure that their ex-spouse doesn't remarry and have all the money go to this entire other family and their kids get
Mm.
disinherited, right? So you want to be careful of that. But also I've seen it where it's an amicable divorce and
Mm-hmm.
the spouse doesn't really want to disinherit their ex. They say, look, I don't plan on remarrying. If I died, I'd want to leave a trust for my ex. And I want then that trust will go on to our kids as we've agreed. And that was our plan all along. But they don't get around to updating their plan.
Yeah, yeah.
So inadvertently, the ex-spouse is disinherited because automatically you get cut off from each other. So you're not always cutting each other out. Sometimes you wanted the plan to stay in place, but you inadvertently ruin your plan.
Okay, that's a little bit. Let me see if I got this right here. So you're saying, okay, amicable divorce, right? Me and my husband, we have an amicable divorce. We're divorced. I don't want to disinherit him because I just like the way everything is set up and we have a trust for our kids. But because we're divorced, he's automatically disinherited anyway. So if I wanted him back in, then I have to do a new will saying my former spouse is my beneficiary.
Yeah.
Okay.
And so, because
Okay.
sometimes that's the best thing for the kids, right? Is that their parent would have the funds to raise them and that the money wouldn't be going right to the kids. So now that you've got trust fund kids, right? Sometimes it's better off for your own children to leave money in trust for your ex-spouse if they're,
Right.
if they're the parent.
Oh, I
Not
see.
all.
I see. So like you're saying, like me and my husband, right? We have our trust set up. And so if we were to get divorced amicably, knock on wood there because my husband would kill me. Well, not literally. If I wanted my husband to, so technically, if we were to get divorced, we're like, we disinherited each other. We can't be our kids' trustees. So for us to be our kids' trustees, we need to come back to you and say, hey, Kanoa, we divorced. We want to make each other our trustees of our kids in case the other passes, right?
Yeah, exactly.
Okay. All right. See, this wills and trust stuff. I mean, this is why, I mean, thank God you got the LLM. But, one thing I want to talk about, and we just, you talked about getting the LLM in terms of taxes. How does that knowledge of taxes help people in estate planning? Because I think that's what as we as simple lay people miss. But does that come more into play with like the million plus estates, thinking of the different tax considerations and things you can set up?
Yeah, taxes, it's important to be, most people think I'm not rich, I'm not a millionaire, I'm not worried about taxes. Plus the estate tax exemption is $12 million per person. Well, that's the federal estate tax. And so,
Okay.
yeah, these days only pretty wealthy people really have to worry about federal estate taxes and trying to minimize those taxes. But the Washington estate tax actually impacts a lot of people. That exemption is only 2.2 million per person. And I know I'm saying only 2.2 million, but with life insurance counts, the equity in your home, retirement accounts, maybe you inherit some money. A lot of people are pushed over 2.2 million, even though they don't feel like they're wealthy. They don't realize they actually have a taxable estate. So you need to know, you need to have a will that's going to minimize that tax by leaving the appropriate trust to your spouse or partner. It's pretty easy to get around the taxes if you just are setting up your wills the right way.
So if you had a state that was 2.3 million, what is the tax liability on that if you don't get it set up properly?
It only starts at 10%.
Okay.
Has a maximum rate of 20%. But, especially in the Northwest these days with real estate values going up, it's so common that I meet someone who they feel like they don't really have much money, but they have, their house is now worth 1.2 million.
Right.
And they each have $1 million of term life insurance, and they have 750,000 saved up in retirement. And they think we're not millionaires, but I say, well, actually, the state of Washington is going to call you a millionaire if you die and you don't have a will. You add that up, that's $3.5 million. Only 2.2 million is going to go tax free if you don't have a good will. Okay. So your kid's going to needlessly pay $200,000 in tax.
Wow.
You could shrug at that and say, oh, well, but people work hard to save 200,000, and there's an easy fix, right? You have a will that just says, if I die, my share of the estate goes into a trust for my spouse. So my spouse is well taken care of. She's the trustee, she's the beneficiary, so she has access to the money, but she doesn't directly own the trust assets. So when she dies, they're not subject to estate tax. So that very simple thing in your wills can allow 4.4 million to pass tax free instead of just 2.2 million.
Oh my gosh. I don't know, but if everybody out there, but my mind is just blown right now. Because I get it how there's a home that my husband and I had sold, I think back in like 2009. We sold that home to buy this current home, and I think we sold it for like 750 or something like that, and it just sold again, and now it's worth 1.1 million or something like that. And so I get what you're saying, where you could have your home with this crazy market that's valued at 1.1. You and your spouse could have life insurance policies worth $500,000. So boom, now you're right there at 2.1. You've got retirement accounts of, who even knows, 300,000 whatever. And now you're just pushed over that 2.2 million threshold. And I wouldn't want it. To me, $200,000 is $200,000. Like why would I want that going to the state of Washington instead of my beneficiaries? It just, it makes sense. And I know it. Wow. I mean, $200,000 is a lot.
So that's why it's very common these days. People who really think it through and go through the process end up leaving a trust for their spouse to save on those taxes. But also to make sure that if your spouse remarries, that trust won't accidentally go to stepdad or stepmom.
Yeah.
It's very good asset protection to leave your spouse a trust, because then that money is only going to benefit your surviving spouse and then your children or whoever the remainder beneficiaries that you picked are. It's not going to go to this new family that you didn't intend to benefit.
That is so true. My husband always, my husband tells our boys, hey, sons, if I pass, make sure your mom doesn't give our money to her new husband. And I tell him, hey, come on, I'll do a prenup, all right? Don't worry about it.
You know what to do. You're uniquely situated to plan for that. But a lot of people find a lot of comfort in knowing it's pretty
Yeah.
easy to protect your estate from that happening. And then a marital trust can also be protected if the surviving spouse is ever involved in a lawsuit. So if your spouse is a doctor,
Yeah.
or an attorney, or drives a lot, anything that is a potential liability, that can be protected with marital trust.
And aside from the big benefit, if you have kids and you want to set up a trust to protect the assets to your kids, especially if you pass and your spouse remarries, you want to make sure the new spouse doesn't get all the asset. But let's just say we have spouses, just a couple and no kids. Wouldn't you still want your assets to be in a trust? Because if the marriage, the community gets sued, that trust protects the asset. You could put the home in it.
Yeah. Very,
Yeah.
very good asset. It's very good asset protection for the surviving spouse to have that marital trust. Lawsuits, remarriage, and then what if you end up in a nursing home someday?
Yeah.
Trust can become a special needs trust, which would be protected from a Medicaid spend down. So even if you don't have a large estate, sometimes you want to have that marital trust. Even if you don't care about estate taxes or remarriage, you say, hey, I saw what happened to my mom. She spent all of her money in a nursing home and we didn't inherit anything because she had to get down to $2,000. Well, a trust can be a special needs trust, which does not have to be spent down to zero.
Oh my gosh. I mean, my mind just got blown again because how many times I've seen that happen, right? Where you have to spend all the money down of that parent so they can qualify. And if you had a special needs trust, you wouldn't need to do that. And then that parent's assets are protected and then you can inherit.
Yeah.
Okay, now I got to check to see if my mom has it set up. No, my mom has no assets. But if she did, I would come to you and I'll be like, hey, set her up with a special needs trust. I want my inheritance protected for Medicaid.
Yeah.
Oh my goodness gracious. I love talking to you. I just always learned so much. It's just so nuanced. There's just so many layers to this. One thing I do want to talk about is, okay, so this is a really big thing, right? And it has to do with guardianships. So when you have a divorcing couple, and I've only seen this happen just a very oh my gosh, less than a handful of times, where let's say I have a divorced couple and dad's not even in kid's life, and dad hasn't seen their kid and like there's no contact, right? Kid is 10 years old. And so mom comes to me and mom basically says, I want to terminate dad's parental rights because if I pass, I don't want dad to come in and take away this child that he's never known. And I have to tell people, first of all, it's terminating parental rights is not easy. It's unless the case is in the dependency proceedings, DSHS is involved. It's really hard. So what I try to talk to people about is establishing guardianships, where you have a will, and in that will, you designate in that will who you want the guardian of your child to be. And it's not necessarily that guardianship is going to trump the parental rights, but at least you're kind of establishing a framework for court. And let me ask you this: how often have you seen that, where people come to you and you presented that fact pattern?
Pretty often people get divorced and they say, yeah, I don't want the ex is not involved in my kids' lives. I would want somebody else to be the guardian. I can do that, right? As the custodial parent, I have that right, to appoint the guardian. And I say, technically, the person with the parental rights is going to trump that unless you can. I have seen a few times people convince that parent to give up their parental rights, maybe for a financial settlement, talk them into giving up their rights, and so that they're not liable for child support, I guess.
Yeah.
But otherwise, that parent who is not involved in the children's lives does still have those very strong parental rights and would
Right.
likely win if they wanted custody of the kids over and above the guardian that you've appointed. That's kind of a
Now,
scary thing.
it's kind of a scary thing, and I think it just depends because especially too in terms of Washington, you have parent can establish to be a de facto parent. So I think there's a little bit more remedy where you could your guardian could be designated in the terms of Washington State Family Law Court. There are avenues now where your guardian can be determined to be a parent and thereby share rights as a parent with bio dad, let's say, for example. But I told people the first step has to be where it has to be designated in the will, because in a way that gives some credibility in the eyes of the court that yes, I get it, that Joe has his biological dad and has parental rights, but I'm also naming Sue as my guardian of the children because Joe, and then Sue would then have to go litigate what her parental rights are, the contact, whether or not Joe has had contact with the children, Joe has abandoned the children, so forth and so forth. But I guess my question to you would be, when you're doing this type of situation, right? You're in this, you're creating a guardianship. Would it help if the person includes as part of the will, naming Sue as a guardian, a notarized statement saying, these are the reasons why I have designated Sue as my guardian, because their biological father, Joe, is completely out of the picture. He has no contact at all with the kids. And these girls consider Sue as their second mom.
Yeah, we do write that into the will when that's how a parent feels, is to say it's my strong preference that their biological parent not become the sole, not be given sole custody, but that this person I'm designating would be a better parent, and it's in the best interest of the child to have this guardian appointed. And then hopefully that could be worked out if that ever arose. It's incredibly rare for people to die with minor parents. Thankfully, we don't actually, most of us don't have that much experience with that fact pattern, which is good. But I think that's the theory, that at least you could hope that a judge would factor in the best interest of the children with your input.
Right. The best interest of the children. So you do kind of write that. So it's actually written into the will. This is the preference.
Yeah.
Okay. So it doesn't necessarily need a sworn statement attached, maybe 1 or 2 pages going into the nitty gritty of the details and such. That's not required.
We usually keep it just a general statement in my practice. Yeah. And sometimes you have to write in, I really don't want my mother-in-law to be the guardian. Like, it's definitely needs to be like my brother, my sister, my best friend. This person has to be the guardian because these other people would not be good with my child.
Okay, I get that. Do you recommend, so if you have a will and well, maybe not then. I'm just trying to think here. If you have a will, so you have a will and you have a trust set up. I'm just trying to think if there's a reason why you'd want to update the age of the trust with your kids, but I guess not. If the trust goes to age 25, I guess you could always come back and say, hey, I want the trust to extend to age 30.
Yeah, we usually, in our office, we have the trusts for the children that last indefinitely usually. Okay, they're age appropriate. They say up until 18, generous. From 18 until 30, it's kind of strict. From 30 on, it can be more generous again, but let the trust just keep running so that whenever they inherit or whatever age they're at, their trust is going to be doing the right thing for them. And even after 30, having that trust stay in place protects your kids if they get divorced or if they're ever involved in a lawsuit.
I see. Okay. Yeah, that makes sense. I get that now. What are some circumstances that you would recommend, or some situations where you would recommend people to get their wills updated? Obviously divorce is one instance. What are some other instances that you can think of? I can think of maybe like buying a home, buying new property.
Yeah, it's mainly when your net worth really goes up. That sneaks up on people. When we did our wills 10 years ago, our net worth was under $1 million. Now it's $3 million. And so we want to add some other beneficiaries. We want to give less to our kids maybe, or be a little bit more careful about what our kids are getting. Or if you buy a property out of state,
Okay.
then you definitely need to update your plan, because you probably want to have a revocable living trust hold any out of state property to avoid probate in that state. And then changing your fiduciaries. So you need to change your guardian or your trustee. It's easy to do. You know, it's not like these are difficult, but those are a good reason to give your attorney a call and update your plan, because, you know, things change in life. And it's the happy thing we get to do oftentimes is people did their wills 20 years ago, and now their kids are old enough and their kids are doing great. So the kids are now going to be the backups for all of these roles, and the siblings and friends that you were, you know, imposing upon to be your guardian and your trustee, they're all released. They won't have to do anything, and your kids slide into that role. So we like when we get to do that type of an update.
Wow, I didn't think about that. Yeah, that's a good point right there. So when I guess when our boys get old enough, then my husband, they're going to be our
They'll be your
trustees.
backup. Yeah.
Okay, cool. It's so hard, you know, when your kids are young right now, but your kids are older.
Yeah.
Wait, okay.
And you get a sense for your kids, and, you know, which strengths they have. Not everybody's suited for that role, but ideally, yeah, your kids, if they're your heirs, ideally they're also going to be the fiduciary, so that you don't have to have somebody else deal with the hassle of managing things for you.
Well, it makes sense. And thank you so much, Kanoa, for joining us today and letting us, you know, get an inside peek at the world of estate planning, wills, and trusts, and why it's important to have this document, especially if you have kids, or even if you don't have kids, but you're looking to protect your estate from the government taking taxes, which leaves less money to your heirs, or even if like, gosh, that whole thing that you're talking about, like with the spend down, where you have to spend down maybe your parents' estate so they can qualify to be eligible for Medicaid and services and things like that. And how can people get a hold of you, Kanoa, if they need your services?
Ostremlaw.com, you know, my website, or if you Google my name is unique enough where I'm pretty easy to find, which is good and bad. No, it's all good.
And Ostrem is spelled Ostrem, the word law.com, and Kanoa, which is what is it? It's a Hawaiian name. What does it mean?
It means the free one, which is kind of ironic that someone that charges, that is not really very free, is called the free one.
And Kanoa is spelled Kanoa. So we've got Kanoa Ostrem here, wills and trust attorney. Please contact him to protect your asset, get things